Much indeed for that. It is 10 to 9 right now. Shorts and selfies, the latest in a series of incidents that's angered judges in Scottish courts. Last month, Sheriff Christopher Sheard said the next time someone appeared in front of him at court in Falkirk wearing shorts, he would treat the matter as contempt of court. And that's exactly what happened. Then last week, 2 men were jailed for contempt after they took a selfie in the dock, uploaded it to social media with the caption, "Ha ha ha, court." So what exactly is contempt of court, and is behaviour deteriorating in the system? Let's have a chat with someone who spends his professional life in court. Thomas Ross KC, one of the country's leading criminal advocates. Thomas, good morning to you.
Hi, good morning, Gary.
So just explain to us, in layman's terms if you would, what contempt of court actually is in this instance.
Well, the legal definition is conduct that it denotes willful defiance of or disrespect towards the court. So that's it in simplistic terms, and obviously it can be constituted in innumerable numbers of ways, and you've just described two.
Yeah, I mean, would you differentiate between the two that I've just described? I mean, one is a sheriff unhappy that people's, attire perhaps is not suitable, and then the other one where, they're laughing and joking and taking a selfie about their appearance in court.
I'd no doubts at all about the ha-ha court example. I'm certain that's definitely contempt of court. I wasn't entirely sure that turning up in court wearing shorts in 2025 would necessarily be considered by the appeal court to be a contempt of court, but probably safer not to take the chance, because that's only my opinion.
Well, I think it would be fairly foolhardy in February in Scotland as well, given the weather outside.
But I agree.
It's very much open, I presume, to the interpretation of the sheriff who's sitting there at the time.
Well, that's where it starts. But of course, if you're found in contempt of court and punished for it, then you have the right to appeal, and then it would be ultimately considered by 3 judges who would be laying down the law for the rest of the country and all the other sheriffs. So you would obtain more general guidance at that point. But the difficulty, of course, is if you annoy the individual sheriff enough, you might be in custody waiting for your appeal to come to the appeal court. So you need to be careful.
I mean, a lot of people might find court a fairly alien environment if it's not something you're used to. And I know often, the officials explain things to jurors, etc. Is contempt something that needs to be explained, do you think, that, not to upset the sheriff?
Well, sometimes we have problems with jurors, who do things that they're told not to do, and often they're, when confronted with that allegation, they give the explanation that they didn't really understand what the guidance was. So in those situations, maybe there's a need for a fuller explanation. I'm not sure in practical terms it would be possible to write to all the accused and tell them of the individual preferences of every sheriff in Scotland. So there's obviously a grey area. Probably best just to err on the side of safety, I would say.
I mean, it's a reverential environment. I mean, have you seen a change in terms of people's behaviour, in terms of, respect towards the system?
Yeah, maybe just a slight change. I mean, certainly the judges are trying much harder to keep the jurors informed, to keep the witnesses informed. There's steps to avoid witnesses coming to court. Quite often we do it by video link these days, and I suppose every time one of the formalities is removed, there's just a danger that the respect for the court might be diminished in some way. But, I'm still in favour of them. It's just something we need to keep an eye on.
When a charge of contempt of court is laid down, what are the most obvious examples? Where is it most frequently used? Is it because of jurors perhaps not following the directions clearly?
Yeah, but sometimes witnesses are not, complying with the oath, sometimes sort of fencing with the prosecution questions because they don't want to, give evidence against the accused. They don't want to accept that they've previously given a statement, that kind of thing. Sometimes they just don't turn up. Witnesses don't turn up and the court has to go down for a day. That's clearly contempt if it's deliberate. And we do have problems with jurors who are routinely told not to do Google searches and the like in relation to the accused history, and sometimes do. And that clearly, having been told not to do it and gone ahead and done it, then that gives the judge a problem, because nobody wants to be punishing jurors who obviously serve a very important function without payment.
The courts need to, if I can put it this way, lighten up a little bit. I mean, they're very much stuck in terms of their traditions and the dress, etc. Not much has changed over the years.
Yeah, I mean, I wondered wondered about the shorts example, because we're in 2025 and
26 now even.
Yeah, I saw 26. Yeah, and there's a quality expected in relation to the way in which people dress, and I'm not certain that a man wearing shorts is so spectacularly different from a female wearing a skirt. So I wondered about it, whether that was really sustainable in 2026. But I don't know that he did make the finding. I think he just warned them that he would if it happened again. So it's yet to be tested in the appeal court. Maybe it's me who's got it wrong, and the appeal judges would take a different view.
Well, or maybe those appearing in court will heed the warning at least. Thomas Ross Casey, thank you very much indeed for speaking to us on the programme this morning. Now, as we've been telling you over the past hour or